Appreciate everyone coming today. As we start, we'll mention this a few times. I know today is a very time-sensitive day, but if anyone has questions, you can start queuing them up on the Q&A. The chat feature isn't available for guests, so if anyone is interested in asking questions about today's discussion, we'll post it on today's chat. We are going to officially start in about 2 minutes. And as we do our buyer side chat, you're welcome to post questions on the Q&A, and we'll do our best to answer everyone's questions.
For those of you who are joining and wondering about that AOS memo, it was Matthew that actually released that to drive people to his webinar. So very selfish of him.
Pretty much. And Niral just got a haircut so he could look good for this
just for this webinar. Just for you.
All right. Well, we've got a nice crowd. We can go ahead and get started. So thank you everyone for coming in today. I know EB5 is a really dynamic environment, and it's just really important. The one thing I really like to just tell all stakeholders in EB5, it's really an ecosystem, and I know EB5 is very blessed to have a good support network of sharing valuable information, and that's really what the purpose of today's workshop is to get diverse perspectives from within the government, professionals that are in the private sector, bringing representatives from EB5 Investor Magazines to be able to kind of address trending things that are happening in the industry. Just briefly with our discussion today, this is not a conversation that we want to have about grandfathering and maybe the same old things we have. So what we're trying to do today is really get into the mindset of how USCIS thinks, how they handle cases on an insider perspective. And we're very blessed today, right, to have this incredible panel. And we'll have them introduce themselves, but we have some very senior leadership, Ricky Murray today, who recently departed the IPO in USCIS, and he's going to be able to share more valuable insights on how adjudicators process EB5 visas. And we have also some expert attorneys here that have kind of seen things on the inside. So the way this is going to shape out today, this is a fireside chat. So we're going to have a panel. I encourage everyone to ask questions in the chat, and we're going to ask questions and get diverse perspectives on these opinions. So as we get started, I'm just going to introduce myself. I'm your moderator, Matt Khalili, the founder of New World Ventures. What I am is I'm an investment banker, and I represent EB5 investors in project diligence, project selections. I've helped investors for the last 15 years, and my claim to fame is I've helped originate over $1 billion in capital deployment in private equity. Not all of it's been EB5, but I bring a more institutional investment banking perspective on due diligence. Today in our audience as well, I'd really like to thank a representative from the EB5 Investors Magazine, Ala, who's been very gracious to sponsor this event. Ala is going to be hosting an incredible event next week in Miami. And Ala, thank you so much for supporting the EB5 investment community with all the resources that you provided.
Of course.
Absolutely. If you can maybe tell the audience a little bit about the magazine and yourself, and we'd be happy to kind of dive back into this workshop.
Of course. Thank you very much. Hi, everyone. My name is Ala, and I'm the relationship manager at EB5 Investors. It's great to be part of today's discussion and to hear such a valuable insight directly from former USCIS leadership and also from leading EB5 attorneys. At EB5 Investors, what we do, we work closely with developers, regional centers, migration agents, investors, and all the active players in the EB5 space to provide them with the most useful resources and connect all these parties together. So definitely I want to extend invitation to everybody here to our upcoming events, EB5 and Global Immigration Expo in Miami, June 1st and 2nd. So we can keep up all the useful conversation in person, but definitely today it's going to be a very useful discussion, and hopefully everybody will be taking useful notes so they can move forward in their EB5 plans.
Thank you, Ala. And it's, if I'm not mistaken, it's free for investors and for other stakeholders. We can buy a ticket. I believe it'll be posted on the chat if anyone is interested.
Yes, of course. It's free for the investors, and definitely they can visit the link and just sign up, and hopefully we can see them soon in person.
Absolutely. All right. Now, without further ado, panelists, wonderful, wonderful people who many of you I know personally. Ricky, Murray, can you kindly introduce yourself and your background so the audience knows who you are?
Sure. Thank you. First off, thanks for hosting this event. Really looking forward to talking a little about USCIS and IPO. So just a little about me. I actually just left in last December, and started a law firm, Jet Global Solutions. We are a full service immigration firm, and we represent investors as well as all kinds of other immigration things. But for this purpose of this, I was with USCIS for 18 years, and during that time, I was a field office director at various offices within the United States. I worked in refugee and international operations as a chief of staff, and for the EB-5 program, I actually spent quite a bit of time with the EB-5 program. I spent numerous years as the policy branch chief. I started the policy branch there at IPO and an EB5. And then I was a division chief and worked my way up to the deputy chief. So I was the number 2 in the office that oversaw it for a couple of years. So yeah, I've reviewed many different projects, as well as hundreds, if not thousands, of investors. And yeah, I've reviewed their cases and understand the process. So excited to share that with you guys today. You're on mute, Matt.
Matthew, you're on mute.
Thanks, Niral. Thank you, Ricky. So we have a lot of questions pouring in, and I know there's a lot of interest in what's going on with the adjustment of status memo today. We will definitely be talking about that at the end of some of these questions. So feel free to ask those questions, but I don't want this to be just about this memo today. So please, as you're posting questions, let's talk about how USCIS thinks and handles cases and things that might be useful in that regard. So Niral, tell us about yourself and your practice.
Usually I defer this part to Phuong, but without sounding too arrogant, I feel like a lot of people in the audience who we recognize already know who we are. We're partners at KLDP, full service immigration firm specializing in EB5. Phuong and I have worked on thousands of investor cases. We've helped regional centers get established. We've filed 956Fs. So we've seen the entire life cycle of the EB5 program. But we're excited to share this panel with you guys today. And I say, let's get right into it.
Yeah.
Awesome. Phuong, anything you want to say, or are you too cool?
No, Niral introduced us much better than I could. So for anyone who wants to start a company, you should find yourself a Niral and then go do it. So yeah.
All right. Sounds like a plan. Okay, so let's dive into it. This is a roundtable, so feel free, all three of you panelists, to chime in. But let's just set the tone. Ricky, for you, I know you spent a lot of time at the IPO. Can you just tell us, has the IPO changed over the years? And just tell us, like, more recently, how has it dramatically changed, like, now as of recent times in your experience?
Yeah, so yeah, when I started in about 2016 with IPO. Maybe it was a year or two before that. But when I started, we just moved to Washington, D.C., and the office was about 35 people. So it was a really tiny shop that was really kind of starting up the IPO program. And by the time I left, it was about 250 people. So we had a lot of growth during that period of time. But as we were sort of scaling up, one of the most important things for us was really sort of trying to make it a self-sustaining unit, trying to embed policy and embed fraud detection, national security, embed the economist, and really trying to make it as a unit that functioned by itself. One of the things that I think everyone knows is EB5 is very unique in the immigration world. I mean, there's just not a whole lot comparable to it. It doesn't fit the sort of other categories, the EB categories or the family categories as smoothly. So it was really sort of important to build that unit out into a unit where you could specialize that knowledge and ensure that sort of all the pieces of the puzzle knew enough about the program to make it work smoothly. And I think we did a pretty good job of that. I think one of the things that's really changing lately, unfortunately, is that they are kind of dismantling that setup that we had. And I do think that's leading to problems, and it's sort of foreshadowing some problems I see coming along the way. They took out the policy program. The policy is now being done at the Office of Policy and Strategy rather than the actual IPO. So that policy isn't necessarily being done by people who have the base of knowledge in the program as it's happened in the past. And I do think that's something where then if you don't have that specialized knowledge, that means that some of the rules, they're not going to understand necessarily how that affects the industry, how that affects the actual work of the IPO. It may be idealistic or fit like sort of the policy goals that the agency has, but it doesn't necessarily mean it's going to clearly fit or cleanly fit sort of how IPO and how the ecosystem actually, the EB5 ecosystem actually works. And the same with FD&S. I mean, one thing that happened is they got taken out of IPO as well. So sort of anything that has to do with the fraud investigations or things like that, that's also being done by people who don't necessarily have that knowledge and skill set of the EB5 program. And one of the reasons, especially for them, that we put that in there, it was really important for people to understand the program, because we had a lot of cases where investigators went out and said they found fraud because, let's say, an investor in the regional center, they went to a project site in, say, California, and they said, hey, do you know this individual? And obviously the project's not going to have any idea who this random investor is in like an enormous capital stack. And so they would come back as fraud, and we'd have to go back and explain to them that's not fraud. That's not how the program's set up. And so, yeah, there's things like that I think some of the dismantling under this administration is really kind of making it a more challenging environment for IPO to operate. So yeah, I think those are some of my concerns and kind of how we tried to build up the program at the time.
Yeah. Ricky, thanks for sharing that. And I think that's actually a more critical point than people probably realize, because I think EB5 is complex, it's complicated, right? And with each iteration, I feel like there's all these new wrinkles. So in the past, I think IPO did a pretty good job of kind of seeing what issues would pop up. It might take a bit, but you guys release guidance, and more or less for the most part, I think the industry agreed too. I think post RA till now, there hasn't been very much at all. And so it seems like what you described is probably the result of that, right? No one's writing the policies anymore.
Yeah, I will say too, and just an overall change for USCIS that's really happened over this last administration is the policy goals are coming top down rather than from the bottom up. And that's a huge change. I mean, one of the things that I think USCIS was okay at, not saying great, because they clearly didn't get everything right, but we would at least have the ability to talk to stakeholders, understand sort of the problems and how they fit in the puzzle. And we would raise that up to the policy team to write guidance, to push the Capitol Hill on trying to include that into regulations or statutes, things like that. So like there was whole conversations about that, about how to actually make the program work. Right now, unfortunately, with the policy coming top down, we're just not seeing that same engagement with the actual operational units that are actually the ones that know how the program works and see where it's working, where it's not. And so, yeah, I think that inability to actually have the bandwidth to do that policy making, as well as simply the lack of interest to make that decision making, I think is sort of hurting the program and really hurting the visibility of the program with the private sector. The private sector is flying blind a lot of the time, and I think that's a huge problem.
So Rick, just to add, would you say, at least on the practitioner side, right? Like Phuong said, when the the RAA has done a lot of positive stuff for EB5. I mean, we've seen
Absolutely.
better processing times, the fact we can do concurrent filing. It's been kind of investor first, and it's given a lot of benefits. And I really feel like it's only within the last, like, what, 6, 7 months that we've seen this weird, like, random flip of a switch adjudication change at the IPO. So, obviously this administration they haven't really hit the ball. They've kind of said, hey, we want to tighten up immigration, and we've kind of seen that on the practitioner side. What do you see, or what do you think's going on really at the on the officer side of things within the last 6 months compared to, March 2022 and then?
Yeah, so I think that's actually a really important point that you're making. I do think the culture inside USCIS or the government in general has just changed. It's a lot more of a fear-based system than it ever had been in the past. I think there's a real concern with sort of the officers individually making a wrong decision, because there's parts of this administration that haven't had any problem throwing essentially like individual people under the bus for a decision they don't like. And that's something where in previous administrations, like it was much more of a case where you would look at a case and it wouldn't necessarily be a problem if you're able to justify why you made the decision. So like it wasn't necessarily looking at whether officers were right or wrong. It's whether they'd actually thought out the process and really analyzed the situation and made a determination about which way to go on the case. And I think at this point in this administration, my real concern is that people don't feel comfortable with that actual weighing of the equities. They're always going to be more conservative and fall in the way of denial because they don't want to necessarily be responsible if that for some reason comes back to haunt the agency or IPO. I mean, they're the ones that are going to be held more accountable. And I think that has steered everything from the adjudicative side to a far more conservative place than it ever operated from before.
That's kind of crazy because it also puts some context to things, because what you said about how officers are afraid of making a wrong decision, it is specifically in the context of officers who approve a case and someone doesn't like it, right? It seems like we've always thought it should be easier in theory to approve a case, because when you get an approval, it's not like USCIS sends you a congratulations email. They just send you an approval notice. But with an RFE or NORD or denial, they have the right pages, font pages to explain. But it seems like if they do that, it's easier for them to justify than to do an unpopular approval.
Yeah. Yeah, I think you're right. I mean, I think in the past, it very much had been more of a environment where, approval was the easier factor. You don't have to write up a long denial and an in-depth denial. You don't have to clear that with chief counsel. I mean, it's an approval. But under this, I mean, there's just a lot more repercussions potentially for an approval. So there's just a lot more thought given, and it's just become more of a conservative environment because of it.
Thanks, Ricky. That makes a lot of sense. So we're having a lot of questions on how does an adjudicator really feel influence, and what's the perception with these writ of mandamuses? At the beginning, right, it was used sort of selectively, and we've been seeing people use it much more aggressively now. So at your time there, like as when you were leading your team, how did you guys perceive these writ of mandamuses, and what's the psychology behind responding to those?
So I think there's a little bit more background to that I kind of want to shed on that, because once it actually filters down to an officer handling a case that's a mandamus, they're not going to look at that any differently than any other case they handle. I mean, essentially, I'm sure the completion amount has changed a little bit, but during my time, it was essentially the goal was to complete 10 cases a week. If it's a mandamus or if it's not a mandamus, it didn't make a whole lot of difference to the actual adjudicator. The difference nowadays that I see with mandamus has far more to do with staffing and resource levels at all of the various higher levels parts of the federal government. Right now, especially when you file with the AUSAs, the AUSAs have been completely stripped of personnel. I mean, those people have left, like they're on a skeleton crew, essentially. They don't have time to deal with individual mandamus cases. So they're pushing back extremely hard on mandamus cases because it's something that they don't want mandamus cases coming unless there truly is sort of these have been far pending longer than anyone else, or they're far outside of normal processing times. I mean, so that you get the pushback there. There's also the pushback at USCIS and some of the other levels at USCIS too, because it's more work coming in for them that's immediate. They have to take care of it. And once they take care of that, that pushes other priorities back. So taking on a lot of those cases is something that the agency is just really struggling with at this point. So I think there's a much stronger push to try and not let those mandamus cases get to that officer in the first place. And I think that's sort of more the pushback than the actual adjudication. If they actually get to the adjudicator, it really doesn't make a whole lot of difference to the adjudicator that it's a mandamus case or not. I don't see them necessarily analyzing it a lot differently than any other case they have.
But then, and it's funny, right? Because it's a problem of the administration's making, because they strip USCIS and IPO of resources. Obviously, the amount of applications is still going to go up, but because you don't have any resources, it takes longer to adjudicate. And so, which is forcing the mandamus filings that they ultimately don't want to take on.
100%. This is a completely cyclical situation, catch-22, whereas, yeah, you've taken resources away, which delays everything, which means that more people are going to complain and file the mandamus, and
Right.
they don't have the staff to manage it.
You know, the other thing is this. One thing you touched on, which I think is important, is that look, I mean, mandamus is an important, effective, it's one of the only effective ways for you to push your case through, right? If there's unreasonable delay and everything else. However, I think a lot of times people think that when they file mandamus, it just goes straight to the officer's desk. U.S. attorneys are gatekeepers essentially, and they're being overwhelmed. So, you know, when ideally in a situation where we're able to step in and kind of negotiate and discuss equities and everything else, that'd be ideal. But when people are filing mandamuses after 2, 3 months of filing 526E rapidly, it kind of creates a lot of problems for everybody, you know?
It's also created some, at least in some districts, some pretty bad case law that hurts the
Yeah.
ability of mandamus cases to the real like needed mandamus cases to move forward. So I think that's also something, especially where so many of the federal government and like the adjudicated ones are being filed in the District of DC. You know, like that court, like the case law there is not great, and part of that is it's due in part due to the sort of the mass filings of mandamuses that they've received.
Well, and it's important for the audience to know that a mandamus, this is a lawsuit that's filed in federal court. It's not an application with USCIS. And just like any other sort of lawsuit, there are so many factors that go into whether a mandamus is appropriate at this time. Even our advice 6 months ago on a mandamus is different than what it is today, and it will likely change 6 months from now. It's always very, very fluid. So it's important for the audience to keep that in mind, that yes, mandamus is a useful tool, but there is an appropriate time, and we have so many factors to take into place, whether it's venue, whether it's a specific judge, whether it's obviously processing times, how USCIS is fighting back on it. All of these factor into whether we've actually filed a mandamus.
And mandamus is an important tool, but one thing mandamus is not, right? And we stress this to people, is it's not a proxy for premium processing. It's not like you can create your own option for expedited processing. That actually just screws it for everybody, right? So if you think about it, the more, I wouldn't say frivolous, but if you get aggressive, then it makes it much harder for everyone to get relief, right? So something to consider.
Yeah, if everything's a priority, nothing's a priority.
Yeah, if everyone has status, nobody has status. Exactly.
Yeah, thanks, gentlemen. So a question we get asked pretty often, and we see a lot of this in the chat, right? How is an adjudicator really looking at partial filing? Is there any discrimination, or do you guys look at partial filings with a little bit more scrutiny? But what is your psychology when you see a case with partial filing, Ricky?
Yeah. So just a little about sort of the history of that. I mean, like for a long time, partial filing was really something we only saw in the standalone context. It wasn't something that was necessarily in the regional center world. Over the last handful of years, that's become far more popular. Um, I think sort of going back to my original points about sort of that conservative viewpoint, there's always been a bit of tension, and I know they're not direct tension, but between eligible at the time of filing and the partial investment. Because if you haven't invested the full amount, it's hard to there's that tension about then for are you eligible at the time of filing? Because we haven't actually been able to do the source of funds, the path of funds of sort of that specific money. And as you know, USCIS treats money as unreasonably infungible. Like it's not like it needs to be those exact dollars, you know. So I think that tension, and especially in this environment, has caused the sort of threshold of getting past that partial filing to go up considerably because they nowadays with the way they look at partial filing is you really even if you haven't put in the money you still need to really explain where that money is going to come from, where it is going to get to the United States. You need to basically do sort of a hypothetical analysis for them to sort of get past that point of comfort, even though it's preponderance of evidence. I mean, like they're still looking at that now as an extremely high threshold. And I will say, I don't think it's nothing written in this rule, but I do think there's some skepticism there in the agency about sort of how that all works, and are you going to actually get that in, and is that money going to come from that place you said it was going to come from, you know? So for all those reasons, I think that the bar on partial filings is extremely high the way USCIS is adjudicating at the moment.
You know, one thing we also, so this is a topic that we discussed a few days ago, Ricky, right? And so I think it's important because a lot of times, like, there are terms and issues that people throw around in EB5, but it doesn't always mean the same thing. It's not always universal, right? So even this concept of, I think, partial filings, what a lot of folks don't know is that it's not universal how firms approach this. And I think there's a definite, like, there's probably a better way of doing it and a not so good way of doing it, right? So, for example, it's not just that you put in initial amount of money and then later on you fund the rest. I think what it is that it's like you have to put enough, right? You have to show you're actively in the process of investing. It's almost like a set of best practices. You identify where the rest is coming from. You do have to source the rest of it because you almost have to set it up. Versus if you just do a skeletal filing with nothing there, it's kind of hard to accept that, you know?
Yeah.
Yeah. Thanks, Phuong. So we're getting some questions about a little bit of the history of the IPO and USCIS. Like in the past, there used to be a lot of stakeholder events that allow participation from the private sector to discuss, and they've stopped that over the last few years. Why do you think they did that? And do you think they're going to allow our voice to be heard with events in the future, or where do you see the direction of that going?
So unfortunately, under this administration, I'm honestly I'd be a little shocked if that communication really improved. But I can just tell you from my experience in the past, it was really helpful to hear the perspective and go to those stakeholder events. I spent a fair amount of time going to stakeholder meetings, conferences, things like that with EB5, and really sort of hearing about the problems and trying to understand where we could fix things, and especially. I was the lead author on I think it was the 2019 EB5 monetization rule. And I know when I was working on that, I mean, getting data from IIUSA and some of the other areas out there, I think was incredibly important. We didn't necessarily say it, but at least to understand sort of percentages. One thing USCIS is getting better at, but hasn't historically been great at, is sort of data capture. So it's like hearing from the public about numbers in certain areas, percentages of different type of cases. That's super valuable. So I guess I've done my pitch on why I think it's important. But as to sort of go back, I do think this administration is making it much harder. They don't want to announce large scale rules. They don't want to announce changes because things like that trigger lawsuits. And this is my presumption. They trigger lawsuits, they trigger questions, they trigger investigations, they trigger congressional action, you know. So like a lot of stuff is just kind of more verbally being said rather than actually put into actual guidance. And since there's nothing that's actually being really written down on this, it would make doing a stakeholder event extremely hard. So I sort of understand where they're coming from on the fact that those aren't happening more. I mean, because I don't know what they'd be able to talk about considering this. Most of the information that they're sort of the changes and things they're getting aren't necessarily written down in any sort of policy document that they'd be able to cite or rely on. So it would be sort of really hard in this environment to do that, do those type of events.
I think that's the most frustrating part, right? Because even like I said, over the last 6, 7 months, when we've seen these adjudication trends, it's not as if USCIS is coming out or IPO is coming out with an announcement saying, hey, this is what we want to see in future filings. We're kind of having to piece it together with really poorly written noids, RFEs, and denials and try to figure out what the heck it is that the IPO wants. And it's a little bit of a guessing game. We're
No,
like, we think this is what you want, and we think we're providing it, and you almost have to read their mind. But I'm not entirely confident that they know what they want.
no,
And so it's becoming a little bit impossible.
I think you nailed it on the head. I mean, I think the thing is like they know what they don't want, but they don't know what they want. And I do think that leads to it. But I think sort of talking about the process, I mean, the stakeholder engagements, I mean, it was really interesting to figure out where the problems were. And that's where then we would work with the policy units in the past to say we need policy manual updates on this specific area. We need to have a working group to figure out how to make that work, and then we could provide guidance. I mean, yeah, I think right now the hard part is that everybody's only getting piecemeal. And for the record, I think the EB5 industry is more equipped to deal with this administration than virtually any other group because you do actually have a bond that works together really well. So you are able, it's been interesting for me in this environment to see all of you guys talking, all the attorneys talking and seeing kind of comparing notes on figuring out sort of what's working, what's not, and kind of putting that together into something that's going to be functional. But yeah, they really need like more updates to really tell you exactly what you said. You need to tell me the right way they want it, because I don't think the issue is we may gripe about the way we have to do it, but if we know we have to do it that way, at least we're able to do it that way. And instead of just guessing and saying, like crossing your finger and saying, I hope this actually works because I don't have any better guess and it seemed like it maybe worked for others. You know, that's not a good environment.
Yeah, putting a black box between communication between IPO and just the EB5 industry in general, I think that creates a lot of problems, you know. I think the EB5 industry, for the most part, you know, we see what the issues are, and it's hard for the industry to work through them. So during these stakeholders call, when these issues come up, when people have different proposals, right, that was extremely useful, but we don't have that dialogue anymore. Now we're left to kind of like have to find out weird ways to triangulate this, right? Whether it's through AILA and their EB5 committee, and we're just giving case examples and everything else, or writing articles. Just it's almost like you're just trying to find some way to get in front of them, but there's just no back and forth.
Yeah, thank you, Phuong. I've been getting this question a lot, right? In the US, there's in source of funds, people are using Cash App and Zelle to pay friends, and it's messing up the hygiene of source of funds on a lot of people's tax returns. How does USCIS look at transactions like this between friends? And if friends are unwilling to support tax returns and data to support that, is that becoming very problematically on your end, Ricky, or are these very explainable things, people paying their friends on Zelle, etc., to USCIS?
Have less friends.
Say it again.
Have less friends.
Yeah. Yeah. I mean, this is another thing that I think it would be helpful to understand exactly where USCIS is coming from. And like, I think that that goalpost is changing. I mean, previously it had been, these are the situations that if you explain and you, many times, if not most times, it would be fine if there's one transaction that you don't have the full documentation, but you can explain exactly why, who was involved, like everything else, they'd be okay. Nowadays, like sort of again, going back to that theme of conservatism of the adjudicators, I mean, they're wanting everything to be 100%. And that's a really tough environment. And that really strikes a chord with the issues between preponderance of the evidence, which is 50 plus a feather. I mean, that's how I was trained to look at it. I mean, like that's not 100%, but right now the documentation on all like sides of the transaction, it's not even like one side of the transaction. They want to see the bank account before, they want to see the document from the transfer, they want to see the bank account minute on the other side. They want all three of those, or else it's not fully complete. So I mean, yeah, the situation now is they want a lot of documentation. I just don't really see that changing
Yeah,
at
I
this
mean,
point.
it's completely over the top. I mean, before we were even, when we were filing cases and preparing source of funds, we were able to just give sample bank statements. You provide maybe 6 months out of the year for the last 5 years, and that was good to go if all your income was coming from there. Now they want every single bank statement for however long it took you to accumulate those funds. And then it almost seems like, they're kind of running it through these LLMs and then finding out, picking out transactions and then they're issuing RFEs and NOIDs based on those transactions. I mean, we've seen crazy NOIDs where they're asking for $50 Zelle transaction, from
Yeah.
like a
Yeah.
year ago, 2 years ago. And it's like, how does this play such a big part in the overall source of funds? It's insane.
Yeah, and it's extremely tough for me. I mean, looking at it, it's like when it's beneficial to them, funds are fungible, and when it's not, they can't be,
Yeah.
So like it just, you're always on your heels. And yeah, some of those things are just incredibly hard to explain when you're talking about, in many cases, like many, many years ago, and they're asking about a very small deposit. It's like even if it's like gifted with someone, like I don't have any idea what a Zelle payment for $150 from 4 years ago would be. I mean, like some of this to me, like when I was training officers there, I mean, we stressed like the reasonableness test. You were supposed to look at it and see like, would you be able to provide or answer the question that you're asking them? Like that was kind of the theme of the training. I mean, there were expectations. There's obviously the law and regulations about what you need, but like a lot of things, like we're training, you can't expect the exact same documentation from something in the 1990s as in something that happened a year and a half ago. I mean, that's just not realistic that people are going to be able to have that same level of specificity. It's just impossible.
Yeah. And then I think especially, I mean, like, look, there's not a single bank account in the world, not Ricky, Niral's mine, maybe Matthews is clean, but like nobody just deposits their salary into the bank account, right? Like that's just weird. Like people have friends, they go out to eat, they sell each other money, right? You give loans to friends and family and everything else. You might have rental income. It's almost like I feel like the only thing you can really do is make it very clear that your funds came from X and all this other weird stuff, which you do explain was not part of it. But even then, it's like it becomes, I get it. Investors look at it and they submit it, and when you ask them about these transactions, it makes you feel very naked, like we're attacking you, but we're not. We just want to know.
No, and that's one thing for the investors that I think is important. Like at this point in time, these are the questions that the attorneys and good attorneys need to ask. They need to get that granular into the discussion of source of funds, and that does make investors uncomfortable sometimes and really question whether you're doing the right thing. But I mean, I think we've all seen those noids and RFEs that are asking for such minuscule items that it is better to actually finish that whole source and get all that information as much as you can up front and put that together in a cohesive package. I mean, another thing that I always try to tell everyone, at least from the adjudicator side, you want the adjudicator only to look at your file one time. The more times they're going to look at it, the more things that they're going to look at and potentially find a problem with. So if you have that all together in one cohesive package is up front, that's the way to get it through rather than just kind of cross your fingers and hope they don't ask about it. And then you have to deal with it on a RFE or annoyed because that could open a whole nother can of worms that you don't want to be involved in.
I will say though that even if they do ask for ancient documents on an RFE or NOID, I still see that the IPO is still accepting of secondary evidence. They are still accepting of declarations, sworn affidavits, and things like that for documentation that you can't get from more than 7 years ago. So to their credit, which obviously it's hard to give, but to their credit, they are at least still accepting that. So for a lot of people who take out HELOCs, who sell their property, whether it's inside the US or outside the US, we understand that, you might have bought this property 10, 20 years ago or it's passed down through inheritance or generation. And those are still, you're able to explain it, and the IPO is still accepting of that.
Thanks, Niral. A question we're getting asked a lot in this chat is about the SDIRAs, self-directed IRAs. We've been hearing a lot of mixed opinions, especially from our clients. Like, I know a lot of attorneys swear by it, and some attorneys are more cautious about it. Ricky, how have you seen SDIRAs evolve as an adjudicator? And is that money considered really in their control? And how are you guys treating SDRAs as you were in the IPO?
Actually, I'd probably ask for better like up to date stuff. I'd ask Phuong and Niral like sort of how they've been handling it.
Yeah. It's funny because it's funny that this is still such a crazy issue, right? But like for us, Niral and I have been very consistent about this. We are 100% okay with it. So for those who our general rule of thumb on any issue, right, or any strategy is if you don't feel comfortable with it, or your attorney doesn't feel comfortable with it, don't do it. But at the end of the day, what's an SDRA? It's not exotic. It's did you make the money? Is it do you own the funds, right? Are you investing it? You are, right? So it's at the end of the day, it's money in a custodial account. It's being invested. So how is this different than the custodial accounts that we use for minors, right? So it doesn't really make sense for USCIS to accept money from minor children, but not US-based adults in retirement accounts. It's the same thing. So
Well, also at USCIS, this is the least controversial source of
yeah,
funds.
we have like 20 other
all
things.
the time.
Yeah.
The only times we've seen an RFE about SDIRA was not even about the structure of an SDIRA. It was about a particular custodian, and even that custodian provided all the necessary documents to respond to that RFE, and it got approved. And then we just include that as part of the initial source of funds moving forward. It's become the easiest source of funds.
Yeah. That RFE, by the way, so if you have an issue with that RFE, by the way, didn't even, like Niral said, it didn't even challenge that SDRAs were legal. What they basically asked was like this company that you used to open an SDRA, like prove to us that it's real. Prove to us that this is not illegal and licensed. And it's almost like when we looked at it, it's like, did you Google this company? Because it's been around for like 15 years. It has like $3 billion like assets under management, and they gave us everything. It's the license, their funds, their custodial agreements. Those things are easy. I expect in a month or two, this should no longer be an issue. So we'll see.
Well, that's great to hear because like I've been a little confused by the issue because yeah, for the USCIS side, there's nothing inherently wrong with
Yeah.
it. I mean, like I've never really thought of it as a considerable issue, but I've noticed in some of the chats and groups that I'm in, like there's so much discussion about it, but it's fairly non-controversial within USCIS. I mean, as long as it's done correctly,
I think it's also very hypocritical for like RCs who seem to have some issue with this. If these same RCs were okay with creating subscription agreements to accept money from like minor children in China, but now they're not okay with doing the same thing for people retiring accounts in the US, that doesn't make any sense to me, right? So it's to me effectively the same thing. So, and this is less controversial.
Thank you, Phuong. And I have another question, and having many questions on this memo. So we're going to get to this memo. But first thing is you kind of touched on this, Phuong, a little bit, but it seems that you're assuming that USCIS is using LLMs and AI to address some issues. Ricky, when you were there, is USCIS really adopting AI to review cases and what are some things you're seeing as far as checking that? And also I've heard a lot of people, they say that USCIS is checking social media. Have they adopted any AI technology to see what people are posting in there to flag people?
Yeah, so there's limited like AI use there. The background checks, like there's a lot of stuff. There's AI being deployed there with a vetting center that for USCIS. That's really where the majority of sort of the AI bandwidth and infrastructure is being built out for USCIS that I'm aware of. They also have, I think it's called DHS1, which is also sort of an AI system where officers can, on their own accord, basically put a decision they've written in to clean it up. But there's nothing being used as like a tool to actually search the data or sift the data and actually put it into a source of funds analysis. I mean, there isn't anything like that I'm aware of, and I've heard about them really focusing much energy on. I mean, there are the things that I do think a lot of people see as potentially AI is they just see the same statements. But I think one of the things that happens in these big offices, I mean, people basically, you see the same type of cases, the same setups so regularly that teams or offices themselves have basically lists, like a snippet list of like things to cut and paste and put in when you have the same question that's come up 15 times. So like when they see that language, I think it's far more likely that language is simply coming from one of these sort of shared RFE template lists than it actually is of being sort of AI creating the same response on an answer. And it's something too, just the AI I think is great, but it's very expensive. And at least under this last Secretary Noem, there were rules put in place about how much money could be spent on contract services without clearance from that office. And I know that really slowed the ability to hire and staff up some of these areas. So like, because in the threshold was like $100,000, which is nothing in the scheme of like some of these major AI and tech and like IT contracts, and so they were just not like these contracts were just expiring and being unable to be renewed. So I just don't think they have the infrastructure right now to build something like that, even if they wanted, because the White House and DHS level are so focused on security vetting, things like that. That's just where all those resources are pointed at the moment.
So I believe you when you say that there's not an official AI platform, right? That the government has created, has vetted, that they have mandated that officers use. But if I'm an officer, right, and this is true, it's like telling if a company tells all their employees, look, guys, they'll use AI, all confidential information. If I had like my Claude on the side or my ChatGPT, what's to stop me from using it?
I mean, like you'd be violating all kinds of rules,
Fair
and
enough.
like
Fair enough.
which in the government, most people have clearances and other things. I mean, like that, like if you were throwing a whole bunch of like privacy, like documents that are protected by privacy rules, all kinds of other things, into like a open source like ChatGPT, I mean, that would be a significant breach.
Yeah, let's hope that's not happening. Okay, so I know we had this memo today, and we've been analyzing this before webinar, and I think it's very important for the audience to know. Like we've seen a lot of things that seem scarier than they actually are. I'd love everyone's input here on what you guys think. Is this any new policy change and anything that can you guys talk about exactly who this memo really affects and what changes do you guys expect as a result of adjustment of status? For those of you who don't know, there was a memo that came today that talked about, how adjustment of status is going to be treated in the US with concurrent filing. Ricky, what's your take from USCIS perspective on this? And Niral and Phuong, like, is this something we should be worried about? Who's this going to really affect?
I think Niral should kick it off. He actually wrote out something that I thought was really, really good on the subject. So I'll just tag off that. But Niral, if you want to go first.
I mean, I think, it's surprising and unsurprising. I think anytime USCIS announces something, it is automatic panic because it is, it's more bad news than it is good news. But I think the memo that we saw today is in line with the rhetoric that this administration has kind of been spewing over the last few years. This is another way for them to tighten immigration, to limit immigration in a sense. But I think, reading through it and I think, taking some time to digest it, it also provides guidelines as to exactly what it is, right? So now the government is pretty much saying that, an adjustment of status is, it's more discretionary than anything else. And I think it's geared more towards your single intent visa holders, like your B1, B2 holders who come into the US and eventually file for the adjustment of status, or maybe even sometimes your F1 students who come in and immediately apply for adjustment of status, those types of visa holders. I don't think it really impacts your H-1Bs and L1 dual intent visa holders as much, especially if they have a clean immigration, they haven't violated their immigration, they haven't violated any sort of, civil laws or anything like that. If you've been in the US and you've kind of maintained your status, haven't violated anything, I think the adjustment of status is still a good process for you. This is the administration's way of kind of weeding out some of the more abusers of the adjustment of status who come in on that single intent visa.
I agree. I agree. And so part of it is, if you have had an unexciting life in the US on H-1B, you don't have any violations, right? You're not a criminal, whatever else, you should be fine, It's important to remember that the RIA specifically allows for concurrent filing. And H-1B is a dual intent visa. So, there's a tendency, and we understand that when news pops out or scary memos pops out, or God, now we have scary tweets, right? But it's a tendency to just freak out initially. But when you step back and look at the overall picture, there should be a framework. Those of you who have had carved out lives and careers in the US on H-1B, you have families here, you have nothing more than one or two speeding tickets, you should be fine. We were talking about it earlier, and we are more concerned about possibly our F1 students, right? So if you just came in here, it's very risky during your first semester, well, as it is right now, to immediately file. But if you're in year 2 or 3 and you've been there for a while, you may have a stronger case there. I mean, we'll see how this plays out.
Well, I think it's also, I mean, this is going to force officers now because they're going to have to issue RFEs, NOIDs, and denials, and they're going to have to give really specific in those responses as to why this person does not qualify for the adjustment of status. So, to your point, Phuong, I think an F1 student who's actually been in the US for a while, in year 2 or 3, they definitely have a much stronger case.
Yeah.
And I still think even the ones who are coming here, they don't necessarily have the intent right now, but that still doesn't mean you can't form a future intent. You can still form that future intent, provided that you're not violating your immigration status, you're not violating any civil or criminal codes or anything like that. That you're essentially clean, you should still be fine.
Yeah, I mean,
Go for it, Phuong.
And would you guys say if someone started a business with an E1 or E2 visa, it's the same as a student, right? If they've been here a few years and been running it, that would apply as well.
I would say so. I mean, we'll have to see, how this goes on a case by case basis. We're also going to need a few months of data to really see how this plays out. And I also wouldn't be surprised if there's litigation right around the corner.
I think the devil's in the details, and I don't think we know enough details about how they're actually going to implement this to have a great idea of how this is all going to work. I mean, I think this is a signaling of where they're headed, but I think we really are going to have to figure out what they do. And I think something Niral said was really important. Like, in order to do this, like, they're going to have to weigh the equities then on essentially every case. And so that's going to be very time consuming, and something I mean, the only change I would potentially recommend at this point is if you're filing a 485, like, it doesn't take too much extra work to put in like some positive equities, like have a paragraph and like provide some information about some of the stuff that they essentially look at the 601 analysis. I mean, so the 601 waiver already sort of does that weighing of the equities, and it's very well listed out, sort of the things they look at, like familiar ties in the United States, community ties, sort of education, sort of if you're hired individuals in the United States. I mean, so those type of things. I mean, like, I don't think it's going to hurt anything to provide some of that documentation and really kind of explain out those positive equities you have in your case up front. I think that'll help you throughout the process as that sort of evolves. But yeah, right now it's just there's not enough details. Like, I do think this is going to be burdensome potentially, but I also agree there's most likely going to be lawsuits, because there's some premises here that I just have concerns with. They're relying so heavily on that this is a loophole, but this is defined in 245A. I mean, like, saying that you can adjust status within the United States. This is not a loophole that hasn't been contemplated. So I mean, that parts of the arguments for this I think are pretty stretched. So I think there's going to be some considerable lawsuits, and I kind of analogize this to sort of the public charge stuff that happened in the last administration. That was a huge concern for everyone up front when that sort of went in effect, like was about to go into effect and was issued. There was all kinds of concern, but it really fizzled out as there was a lot of litigation. There was a lot of things that postponed that going into effect. So I do think there's a reason not to necessarily be as concerned, to something to stay on top of and be aware of what's happening, but it's not something that I think people should be really scared over as of now.
For those of you who are on this webinar, what Ricky is saying is if you are going to be applying for AOS, you should go do some charity work and go to church and take pictures of yourself and submit it with your application. Show that you're a good person, right? But no, if you know, seriously, if we kind of take a step back and we see how this dovetails with what the administration has done, I think it's the public charge is a very good example of this. When it first comes out, it theoretically applies to everybody. But what they were really focusing on was almost low-hanging fruit, right? There are immigrants that the administration doesn't have an issue with, and there are immigrants where they have a huge issue with, right? This coupled with the fact that there's a huge push for, we want to hit these record deportation numbers. So how did you get there, right? So I think when you look through that memo, if nothing else, especially if an officer has to justify whether you're denying it, past immigration violations, past overstays and everything else, those are the people who I think are the low-hanging fruit. That makes it very easy for them to justify. Otherwise, it's hard to kind of figure out like what they would do first, right? So if I'm an officer that has to get my numbers up, it seems like those people will be the most vulnerable.
Amazing. So we're pretty much out of time, but just, this doesn't really change anything, but I've gotten many questions about H4s and OPT, right? Do you think any of those are vulnerable categories from what you're seeing, or everything you just said applies?
I mean, I think everything we said applies. It's not a flip of a switch. It was just announced today. We do need to see over a period of time how this truly is applied. But I think for now, it's very calculated. You speak with your attorney, you understand what your situation is, and I think you follow their guidance based on what's going on.
Yeah, thanks, Niral. Now, if anyone wants to get in touch, right, Niral, Ricky, do you guys provide consultations? Okay.
Yep.
So
I think we spend 80% of our day on our consultations. So yes, we do.
I know everyone has a lot of personal inquiries. Phuong and Niral is definitely available for consultations. Ricky, he's an immigration lawyer as well. He can handle very complex RFE cases. So feel free to consider getting in touch with anyone in this lovely panel. And anyone that wants to learn more, we're going to have an event in about a little bit more than a week in Miami. We're going to get some groundbreaking information. please come to attend the EB5 conference there. We'll learn a lot more, and you can meet with us in person. I'm available as well. If anyone wants help with due diligence and project selection, I'm happy to be a resource. Everyone here is willing to help from this community. I know immigration is scary right now, and everything is such a dynamic environment, but I can tell you, like, it's been worse before, and I know there's a lot of panic, but we like to have a very positive mindset, and we'd love to be there for you if there's anything we can help. So, thank you so much.
By the way,
We'll
just
record.
not to cut you off, but we didn't even get to thank you, Matthew. Thank you for organizing this, especially getting all of us to join and everything else. Lord knows that's not easy, right? So thank you, Allah, for getting all of us together as well. So yeah.
Absolutely, I appreciate it. We'll have this recorded, and we'll try to send this to everybody if anyone's interested. And we look forward to positive changes in the future in getting EB5 approvals.